Justice Kavanaugh?
I'm generally sympathetic to the idea that you don't want to disclose information, national security information, but I think you've said multiple times you already do that when the case goes to the merits in these kinds of situations, so I'm not sure that it's a particular concern if you have to do it in a few more cases to establish mootness, but correct me if...
Well, if you accept respondent submission in this case or the Ninth Circuit, it's not just going to be a few more cases. It's going to be literally anyone who's ever on the no-fly list. The claims could never moot out unless we reveal the information. And, there is a point of minimization. Even, when we have to reveal the information, we do it, but we don't want to, that doesn't mean we do it.
I'm very sympathetic to that, so I accept that. Okay. I'm sympathetic to your mootness argument, although I might not have sounded like it, but the reason I'm having trouble is to squeeze this kind of situation into the test we use. I find very, very difficult. So, and there are two different kinds of scenarios someone could come off the no-fly list that I think might affect how at least I instinctively look at this. One would be we made a mistake. It was the wrong name, person had the same name, this happens, and someone comes off the no-fly list because it was, you had nothing to do with anything, and your name was the same as someone who does. Okay, if you said that, then mootness seems like very easy to establish under the standard that we have. When it's this kind of, connecting the dots situation, it's much harder, I think, to squeeze it into reasonably expected to recur because we just have no idea.
Yeah, so two responses to that. One, I think you hit the nail on the head with the dynamic nature of these things. It's not like, the churches either are or aren't entitled to a grant under the First Amendment. The union fees either are or aren't, chargeable under the First Amendment. Here, it's not static like that. It's not like if you're an individual, you either always belong on or always belong off the no-fly list. It's at the moment, do you pose a threat of engaging in terrorism? And an individual might pose that threat before 2016, not pose it since 2016, and, in 2050 might pose it again. Who knows? But you can never know that, right? And I think that you're right. That is a distinction here. And so then the second part of my answer is I think we need to remember that voluntary cessation is a judge-made exception to Article 3. We're always implementing Article 3. And I think, therefore, it's critical not to stray or become untethered from the purposes of the voluntary cessation doctrine and why this court developed it. It was to prevent gamesmanship and docket manipulation to avoid judicial review, post-certiorari maneuvers, other sorts of things. That's not what's going on in this case. We did not take him off the list in an attempt to evade judicial review, and I think that should be the touchstone for how you apply the reasonable expectation of recurrence, or whatever the language is for voluntary cessation. Don't untether it from the purposes for which the doctrine was developed, because at all times, mootness should not stray so far from Article 3 that they become completely disconnected. And here, he's not on the list. He hasn't been on the list in 8 years. There just simply isn't a live case or controversy about his placement on the no-fly list any longer. And in the unlikely event he's put back on the no-fly list in the future, he can bring a challenge at that time.
Thank you.